Let's understand theories of relationship between international law and municipal law in this video, and why this topic matters for states, courts, and everyday law. Have you wondered why a treaty can change people's rights in one country but not in another, even when both signed the same treaty? This happens because of two main theories, dualism and monism, which explain how international and domestic laws relate in simple, different ways for judges and lawmakers. Dualism says international law and domestic law are separate systems with different sources, and international law becomes domestic only when the state chooses to accept it. Monism views international law and domestic law as parts of one single legal system that bind people and states together and treats international law as superior in conflicts. Under monism, if domestic law clashes with international law, the state is at fault and must still comply with international obligations, even if domestic courts prefer local laws. Dualists see international law as weaker than domestic law, so courts refuse to apply treaties not transformed into local law by the legislature or state procedures. Some treaty rules can work in domestic courts without new laws. These are called self-executing provisions, and states may accept or reject them based on constitutions. In the United States, the Constitution explains treaty power and often treats treaties as supreme law of the land, while some require specific laws to operate domestically. Article 2, Section 2 gives the President power to make treaties with Senate advice and consent, needing 2/3 of senators present for approval. The United States also uses executive agreements, which the President signs without full Senate approval, often for foreign relations or military matters. Trade agreements usually need approval by both houses of Congress, but by a simple majority rather than 2/3, which changes their domestic effect. In England, an old idea said customary international law became part of common law automatically, called the Blackstonian Incorporation Doctrine, so judges could apply custom without new statutes. Treaty rules depend on constitutional practice between the Crown and Parliament, with treaty making being a royal prerogative, so treaties do not become domestic law unless Parliament acts. Today, signed treaties are laid before Parliament for 21 days before ratification, to allow publicity and discussion if needed, except for minor technical treaties. Thus, in England, many international human rights treaties are non-self-executing unless Parliament enacts them into domestic law. So courts cannot enforce treaty rights without local legislation. However, customary international law is accepted as part of the law in both England and the United States. So some international rules apply without new statutes. Conflict happens when international obligations do not match domestic law or when they directly conflict with each other. And then the legal theory determines which law controls. In dualist systems, if a treaty is not self-executing or not incorporated, domestic law prevails and courts follow local rules, so individuals may not rely on international obligations. If there are no domestic rules to decide a conflict, courts may treat the system as monist and give priority to international law. Dualists say treaties must be transformed into state law by specific adoption, not just formal steps, so they really bind individuals through substantive changes. Some see treaties as promises and statutes as commands, but critics say this difference is about form and not the real legal nature. Delegation theory argues the Constitution lets each state decide when treaty provisions come into force and how to incorporate them into state law. Supporters say this is a continuation of the act that created the treaty, not a fresh creation of new domestic rules, and falls within constitutional law-making mechanisms. Although important, the monist and dualist debate is imperfect, and courts and scholars still disagree about the best approach, especially for human rights treaties in common law countries. Many common law countries have moved away from strict dualism, and national courts increasingly favor monist interpretations for human rights law in recent years. Looking at how the United States and England treat international law shows how constitutions, courts, and practice shape domestic application and explain why outcomes differ between countries. So, what do we learn from this? The relationship depends on legal theory, constitutional rules, and state practice, which decide domestic effect. Let us quickly remember dualism treats laws as separate, monism views a single system, and self executing rules may bypass local law, but states differ in accepting them. So, today we learned the key ideas. Keep exploring these theories calmly and check EduRev for more clear explanations and practice materials. Keep asking questions, read cases and constitution texts, and grow your understanding step by step without pressure. EduRev is here to help.